Hello, my name is Erica Minchella. My firm is Minchella and Associates. We handle real estate transactions and litigation in real estate. Today I'm going to talk to you about handling transactions when the purchasers are not married and how to think about the dissolution of those transactions in advance of the transaction falling apart. When we represent people in real estate residential transactions, for the most part, we are dealing with husbands and wives, and we are going to recommend a joint tenancy or a tenancy by the entireties. But when the parties are not married, we have to think about other solutions for them, whether it's going to be a partnership agreement, an LLC, a corporation, or some other vehicle. If the parties are not married, you want to make sure that you are considering whether you have a conflict of interest in representing both parties to the transaction, and you want to make sure that you get a waiver of the conflict of interest if there is one. You should be considering whether the parties should be drafting a partnership agreement at the inception of the transaction so that in the event that the transaction falls apart years later, there's a roadmap for how they're going to dissolve. If they don't think about it in advance, the end result could be tragic. I've handled cases for family members who have wanted to get out of jointly owned real estate. It is not only emotionally draining for the parties, it's also exceptionally expensive. You also want to think about whether there are other options for the parties, whether they should be looking at an LLC, for example. If the LLC is set up, you want to make sure that the provisions for how the LLC might dissolve would be. I have clients who came to me recently with property that was underwater. There were 3 separate couples who owned the LLC. Only one had liability as to the debt because they had a mortgage that was cross-collateralized with another piece of property. They had to buy out the other 2 couples just because they had not considered what would happen if the property was not worth what the mortgage was against it. So considering your options at the beginning, what the entity will be and how the dissolution will look is incredibly important, and it's part of your job as the attorney representing the buyers in the transaction. You might also want to consider whether an alternative would be an Illinois land trust, and then you have to consider what your beneficial interest will look like, or whether the transaction should be through individual trusts that will hold title to the property generally as tenants in common. Thinking about it in advance will make sure that you don't have problems at the closing table or in the event of a dissolution of the arrangement between the buyers. If you have any interest in this topic or any other topics regarding real estate transactions or litigation, make sure you go to the ISBA online CLE archives, and there will be more information available to you there.